All right, aspiring barristers, welcome. If you're gearing up for the Queensland bar exam or just looking to sharpen your skills for practice, you are in exactly the right place. Today, we're going to break down the critical Uniform Civil Procedure rules for affidavits. These are the rules you absolutely, positively have to master.
So let's start with a question. You've got this killer affidavit, the evidence is brilliant, it's persuasive, but is it even admissible? Seriously, think about it. If it doesn't comply with the rules of form, filing, and service, a judge might never even get to see it. Getting these procedural rules right, well, that can be the difference between winning and losing. So here's our game plan. We're going to follow the entire life cycle of an affidavit, from building it and filing it to using it in the courtroom, and of course, how to navigate those common traps. Let's get into it. First up, actually building the thing. We're talking about the affidavit and its exhibits. And let me tell you, under Rule 435, getting these foundations right is completely non-negotiable. You know, the UCPR's definition seems pretty simple, right? An exhibit is just a document used with and mentioned in an affidavit. But don't let that fool you. The devil, as they say, is in the details that follow. And believe me, it's where junior practitioners get caught out all the time. Think of this 5-step process as your playbook for compliance. Every single step here is crucial, from marking and certifying the exhibit with the proper form, that's Form 47, to getting it signed. But you know what the most overlooked step is? It's that last one. The exhibit has to be filed at the same time as the affidavit. If you can internalize this process, you'll avoid so many simple, unforced errors. Now, you've got two completely different paths for presenting your exhibits, and you really need to know which one to use. If you're dealing with physical bundles, you're creating these paginated books, certificate and index right at the front. But for electronic filing, your whole focus shifts to creating one single comprehensive index document that lists everything. And here's a rule that trips up so many junior practitioners. If a document is already on the court file, say it's an annexer to a pleading, you do not re-exhibit it. Just refer to it clearly in the affidavit. This is so important. It avoids cluttering up the record, and frankly, it signals to the judge that you actually know what you're doing. So your affidavit is perfectly built. Great. But it's pretty much useless until it's properly before the court and in the hands of the other side. And that brings us to the next critical stage: filing and service. Okay, the starting point here under Rule 437 is, well, it's pretty absolute. Unless the court gives you leave, an unfiled affidavit is just a piece of paper. It has zero evidentiary status until it is officially on that court file. And it's a similar story with Rule 438. It requires you to serve the affidavit on time. So for an originating application, we're typically talking at least 3 business days before the hearing. The good news is, the rules do give you a bit of a safety net if you miss that deadline, which is the ability to ask the court for leave. You have to remember these rules. They are your procedural escape hatches. Knowing that you can stand up and ask the court for leave to use an unfiled or a late-served affidavit, that is the hallmark of a competent advocate who can think on their feet. And Rule 965, that one is especially useful for those last-minute, 11th-hour emergencies. Okay, you've built it, you filed it, and you served it. Now it's showtime. Let's take a look at how your affidavit is actually used at the hearing, especially when it comes to the pointy end of cross-examination. You really have to pay close attention to the timeline in Rule 439 for managing your witnesses. See, if you serve early, the other side has to give you notice to bring your witness in. But if you serve late, and we're talking less than 2 business days before the hearing, that default position completely flips. Your deponent must be at court, ready to be cross-examined. And failing to produce your deponent for cross-examination, it can be absolutely fatal to your evidence. Yes, the court has discretion, but the case law shows it's almost never used. You risk the evidence being given no weight at all, you could create grounds for an appeal, or you could even cop an adverse cost order. The stakes here are incredibly high. All right, let's do a quick-fire round. We're going to look at some common traps you might fall into, and more importantly, whether there's a way out. So, picture this. You're at the bar table, and you suddenly spot a mistake in your affidavit's form. Maybe there's a missing detail in the jurat, or maybe it's not on the approved form. What do you do? Well, luckily, there's another one of those escape hatches. Rule 436 is your best friend here. It gives the court the discretion to allow an affidavit to be used despite some minor formal defect. It's a classic example of substance over form. Okay, next trap. Your opponent is on their feet and they're arguing that parts of your affidavit are totally irrelevant, inflammatory, or just designed to prejudice the court. And here's the fix for that. Under Rule 440, the court can basically act like an editor. It can strike out those offending paragraphs, or if it's really bad, just remove the entire affidavit from the file. And that is precisely why your own affidavit material has to be professional and strictly relevant to the issues. All right, final trap, and this is a big one. It's late, you're in a rush, and just to move things along, you witness an affidavit for your own client who's a party to the proceeding. You think you're just being efficient. This is where you find a really stark contrast. Unlike the other errors we've talked about, Rule 441 is absolute. An affidavit witnessed by a party personally cannot be filed and may not be received by the court. There is no discretion, there is no fix. This is a fatal flaw. Okay, so let's try to bring all of this together. Before you walk into any hearing where you're relying on affidavit evidence, here is your final essential checklist. Please internalize this checklist. Running through these 5 points before every single hearing is the kind of discipline that separates the prepared advocates from the panicked ones. It's how you're going to avoid those unforced errors and really strengthen your advocacy. And really, that's the core tension that you are going to be navigating for your entire career as a barrister. These rules exist to create a level playing field, to ensure fairness. But your job is to know when they can be waived in the interest of justice, and when they are an absolute unmovable bar. It's all about balancing the letter of the law with the ultimate pursuit of a just outcome for your client.